Welcome to the Celebrity Estates Wills of the Rich and Famous podcast. In this podcast, we break down high-profile celebrity estate planning cases for advisors and their clients. Most celebrity estate catastrophes are based on the same issues that everyday people face, just with the volume turned up. Our goal is to identify and extract the individual estate planning issues that lie at the heart of each story. We then discuss what advisors should expect and how to avoid common pitfalls. Hosted by wealthmanagement.com senior editor David Lenok.
Hello everyone, and welcome to the latest episode of wealthmanagement.com's Celebrity Estates Wills of the Rich and Famous. For anyone new to the podcast, in each installment, myself and a guest take on a different celebrity estate and attempt to extract some key lessons that planners can apply to their more traditional clients. The idea being that celebrity estate planning stories, although often ridiculous in their details, generally have at their cores very basic issues that can just as easily apply to non-famous or fabulously wealthy clients. Our guest this week is Alex Weingarten. Alex is a partner at Venable LLP in Los Angeles. He's a commercial trial lawyer who represents clients in all facets of entertainment, probate, and business litigation. Alex has been recognized by publications from the Los Angeles Business Journal and the California Daily Journal to Variety and Billboard as one of the top 50 trial lawyers in Los Angeles and one of the top entertainment litigators in the nation. He's been involved in a number of high-profile estate litigations, including representing Robin Thicke and his brother in addressing the questions arising out of the estate of Alan Thicke, as well as the sons of legendary film producer Roger Corman in a suit looking to stop the sale of his films. Thanks for joining us, Alex.
Thank you for having me. Pleasure to be here.
So our subject this week is the Queen of Soul, Aretha Franklin. Now, before more attentive listeners get too up in arms, yes, we already covered Aretha's estate all the way back in episode 8. But like estate plans, estate conflicts are living, evolving things, and there have been some changes to this one that bear another look. Initially, when Franklin died in August 2018 at age 76, her family believed she had left no will. Lawyers who represented her said they tried in vain to get her to write one. Under the law in Michigan, Franklin's longtime home, that meant that her estate would be divided equally among her children. Franklin's sons unanimously nominated a cousin, Sabrina Owens, a University of Michigan administrator who was close to Franklin, to be the estate's personal representative or executor. This was where things stood when we recorded our first episode about Aretha. We focused on the ramifications of intestacy. Now, things have drastically intensified since then. And 9 months later, while going through Franklin's Detroit home, Owens found handwritten documents that appeared to be 3 wills. In them, Franklin criticized various people in her life, including a lawyer, an accountant, and the father of one of her sons, and specified how her assets should be split up among her children and grandchildren, in some cases giving her descendants less money than they would have received if there was no will. That discovery immediately divided Franklin's family, some of her sons asking the court to favor one document or another, and led to the removal last year of Owens as the estate's personal representative. In March of this year, Aretha's estate reached a deal with the Internal Revenue Service to pay off millions of dollars in federal income taxes that the singer owed during her life, clearing a major hurdle. However, mere days after this important milestone, a 4th typed but unsigned will was discovered, sowing even further chaos. The question of whether Franklin's wills are valid, and if so, which of them would govern her estate, is set to be litigated at a trial scheduled to begin in August. When we first looked at Aretha's estate, she had no will. Now there were 4. Alex, this is not as uncommon a fact pattern as it may seem. What are your thoughts on how this situation may progress, and what are some lessons advisors can take from this cautionary tale to try and insulate their own clients from potential estate litigation?
So you're absolutely right. It is far from an uncommon situation. Myself and many colleagues around the nation stay quite busy because of disputes exactly like this. First and foremost, what planners can do to attempt to avoid having litigation consume the estate after their client's passing is to do an estate plan. One of the big lessons of the Aretha Franklin case is that there was no definitive final estate plan. My understanding is that Aretha's attorneys lamented the fact that they had for years attempted to get her to do an estate plan, but she refused to do so. So first and foremost is get an estate plan done. And that's important not only to avoid litigation, but the other significant drain on an estate's assets, aside from litigation expense, is taxes. And really the goal of any estate plan is to avoid litigation and, more importantly, to achieve tax efficiency. So none of that accomplished without the benefit of an estate plan. So find a good estate planning attorney, draft an estate plan, and make sure that you have the benefit of someone who knows what they're doing, who can guide you through that process. Another trick that I would, not so much a trick, but something that I would urge anyone who's coming up with an estate plan to do, particularly where you have what I would call complicated family relations. And you typically find this in situations where there are children of one marriage, but a spouse, a second or a third spouse, or you have a lot of money, or you have, some non-traditional relationships that are going to result in a non-obvious distribution of assets or some conflict. Is be explicit. Be explicit in what it is that you're doing and why you're doing it, and to the extent that you can, communicate all of that while you're still alive. I appreciate that that is an uncomfortable situation for a lot of people, and they don't want to have those conversations. But ultimately, the best thing that you can do for your family, or if you want to make sure that you're doing whatever you can to avoid a fight after you're gone, is just to communicate it so there are no surprises and so that everyone knows exactly what to expect.
Yeah, I mean, communication has been sort of one of the grand overarching themes of this entire podcast, sort of in the couple of years that we've been doing it. We sort of present it as the answer to everything, which is both simultaneously like a little silly and reductive, but also like kind of true and obvious that a lot of these conversations are super difficult to have now because we're dealing with death and taxes and difficult, as you said, family situations. But they're infinitely more difficult to deal with when the person involved is not there anymore to talk about how they feel and what they really wanted, and all of a sudden you're left kind of reading the tea leaves from this paper trail from what's left behind to try to guess what they were thinking.
I had a case very early in my career where I had the benefit of having spoken to the decedent before she passed. And she said, and I quote, I'll never forget this. She said, and I quote, "They can all fight over it after I'm gone." She did not want to have the conversation. She did not think it was anyone's business. And ultimately, there was a very significant fight after her passing that consumed a substantial portion of the estate that otherwise would have gone to her children and grandchildren. So that was her choice in that particular instance, but absolutely, it is simple, it is reductive, and it's obvious for a reason. Communication is a very simple solution to most of these problems, really, because when you're dealing with trust and estate disputes, money obviously is a significant portion of it, and the more money you're fighting over, the more intense those fights can be. But a lot of the time, these come down to complicated family dynamics that ultimately don't have a whole lot to do with money. It has to do with this notion that, mom liked me more than she liked you, or vice versa, or you're fighting over, what a colleague of mine referred to as the red tricycle. This seemingly valueless object that has now been a proxy for the emotion of your familiar relationships, that becomes an all-consuming endeavor, and I have to get it and prevent you from having it. And that's unfortunately ultimately what these all come down to. But another factor that you have to consider here is just good old-fashioned greed. A prime motivator of all of these disputes is just plain greed.
I think there's two very important things to unpack there, right? This idea of greed, I know we try to sort of cast our clients and their families in the best light and not be judgmental or be as unjudgmental as we can. But at the end of the day, everyone's human, and sort of greed is a fairly natural. You'd always kind of rather have more money than less money, given the option. So that's something that you're just always going to be fighting with and fighting against. But additionally, I like this idea that you brought up of the red tricycle, and just wanted to expand on that a little bit because a lot of the times that red tricycle, it's not like the one sibling has been harboring a secret desire for it for his entire life and not told anyone. Then that'll come out in the communication. It's more likely that they don't know that they care so much about that thing, or that they don't know that that thing is what's going to become the proxy for their getting revenge on their brother for the time that he scared them when they were 10. And so that communication can help sort of uncover the underlying issue of the red tricycle, as opposed to sort of it's more about that than it is about identifying which of these items is the one that everyone secretly cares about, because they probably don't know.
It's like in Citizen Kane, where Kane's last words were Rosebud, and nobody knew what Rosebud was, and it was really just a symbol of something else. So you're absolutely right. It's not even that people have a conscious understanding of what that issue or what that object is going to be that becomes the manifestation of all of these other emotional issues, these emotional traumas that are going to play out. And it might not be that it was the case that that was going to be the embodiment of all those things before the decedent's passing, and something happens or nothing happens that makes that the issue. Maybe they just want that because the other person wants it. You never know what it is going to be, necessarily, but to the extent that you do know, then again, communication is the key. If the decedent is very clear up front, and this is something is a conversation I have with clients to the extent that I'm involved on the front end. When planners get me involved in the discussion about planning, so that I can take a litigator's eye and really evaluate where I think the problems are going to come up. I tell them if there are any items of sentimental value, if there are any family heirlooms, things of that nature that are going to be issues, then have a discussion about it. Because it might be that if there's a family of 3 siblings and the estate is going to go to those 3 siblings, and you have a discussion about this one family heirloom, it might just be that only one of those siblings wants it. It might be that none of those siblings wants it. I had a case years ago where the decedent was obsessed with who was going to get her collection of mink coats, thought that this was in her mind her prized possession, and really was fixated on this notion of how it was going to be divided and who wanted them. And it turns out she had 4 daughters, and none of them had any interest whatsoever in these mink coats. Because there's a generational shift. I've had other cases where it turns out that the siblings were able to work out, if 2 of them wanted this one thing. This one situation I'm thinking of where there was a medal that had been given to a grandparent, military medal back from China, before the family had immigrated to the United States, that became a lightning storm. And that was the thing they were fighting about. And all it really took was one conversation where they were able to work out a situation where one person really didn't have any interest in it, another one was able to kind of horse trade and get something else that they wanted, and it all worked out in the end. Another common area that people fight over are engagement rings. Everybody wants
Absolutely.
mom's engagement ring. So, and there are lots of different solutions to that problem as well. I've seen situations where there's a sharing arrangement where, one person will have it, 1 month and another person will have it another month. I've seen it where the jewels are split, where if you have a 3-carat diamond ring, they'll get it cut. So now you have 2.5-carat diamond rings. There are all kinds of different solutions, but communication is really the key to anticipating and resolving all of them.
Yeah, absolutely. I'm glad you brought up the jewelry, because I found in both my personal experience and my professional experience that sort of jewelry and art are 2 of the major lightning rods for these sorts of fight, because it's just this weird confluence of taste and sentimental value and monetary value that you can kind of not tell what's going to happen with them. And I've told this story before on the podcast, but coincidentally, my father-in-law is an estate planning attorney. And so, you talked about horse trading. My wife and her brother, and not that there's such an estate to distribute, but in terms of what their parents have, they've already done all the horse trading. He's 70. They're not. He's got a long time left, but because they've been so open about it, this stuff is all settled already. They've already sort of worked it out, and that's maybe a little extreme in terms of the communication expectation for clients. But something that's maybe a little more reasonable to think of is I've also seen families with the jewelry idea do kind of like a jewelry draft, where sort of all the jewelry was left in a pile for people to quote unquote fight over, and instead they sort of brought it all onto a table, the kitchen table, and they sort of decided an order, and then they just took turns picking a piece until there was no jewelry left. And that way you sidestep all this. Oh, who's going to get my minks? It's like, just draft out the minks. So there's answers to these things if you're willing to sort of think outside the box a little, or just even just talk about it a little.
So, to that point, in my own personal experience, before my grandmother passed, she sat down with her daughters, my mother being one of them, and they went through everything. And in that process, it was a wonderful experience because they were able to relive family history and share these fantastic emotional memories with each other by going through this stuff. And I think that ultimately that was more valuable to them than the things. And to the extent there was a discussion about who got what, it was really a connection to the memories associated with those things as opposed to the value, because the few things that there were ultimately disagreements about had very little, if any, monetary value. It was their connection to cherished family memories. And through that process, something that everyone dreaded actually became a wonderful memory that they all treasure to this day.
I think that's a really awesome point that you bring up, and it's something we haven't super touched on in the past talking about this topic. Is, we kind of get fixated on the idea that, oh, this is a ghoulish conversation that is going to be sort of like mercenary in nature, to head off an inevitable fight. But, it doesn't have to be this negative experience, right? It can be you're going through these things and, oh, I'd like this one. And let me tell you the story of why I would like this one. And that's a nice moment. And that's a really special sort of bonding experience, especially towards the end of someone's life, to sort of, to bond and to sum things up and to really have this wonderful sort of recollection of what was going on. And I think I'm really glad you brought that up, because that's, I think, a really beautiful sentiment that happens very often and is we kind of forget about when we get caught up in our, how do we stop the fight? Who's greedy? Who's not? Kind of more dollars and cents discussion of this topic.
Couldn't agree with you more. And it really, ultimately, listen, the families that are able to communicate these things, I find, are stronger knit families. And so they are less prone to have these traumatic discussions because open and honest and frank communication is kind of interwoven into the fabric of the family. It's, when the relationships are defined by stuff and by money, that's when you have more conflict and more problem, and you'll have less of an ability to have those positive conversations around them.
Mm-hmm. So thus far, we've mostly talked about the before aspect of things, the prophylactic measures, if you will, to sort of try to take before the fight breaks out. Unfortunately, my understanding is tend to come in more often in the after, when there is now a fight. So, we talk a lot about avoiding litigation, how to avoid litigation. You don't want to get involved in litigation, but we don't really talk as much about on this show like what that actually looks like. So, if you don't mind, could you just sort of lay out for us? I know every case is going to be different, but sort of what this sort of estate litigation looks like, just for a family.
Estate litigation is frequently one of the most traumatic experiences a family can endure. And aside from the inherently stressful nature associated with any litigation, what I find is it is further intensely emotional because of the personal nature of what it is that you're litigating. And it also comes on the heels of a death in the family. And so you have all of these very complicated emotional issues tied up in the stress and angst that is already associated with litigation. When you are litigating on behalf of Corporation A against Corporation B involving pile of money that ultimately will not have a material impact on either of those companies, or maybe even if it does have a material impact, it's not an emotional issue for either of those companies. That's one type of litigation. But here, you're dealing with raw, naked emotion added to complicated family dynamics, added to really dealing with people at their absolute worst. You've got people grieving, combined with this sense of unresolved familial conflict and issues, combined with, I've said it a few times, but I really can't emphasize enough, the inherent stressful nature of litigation. And so it is an incredibly traumatic experience. And one of the things that drew me to this particular line of work was I find, because I've done and I continue to do general commercial litigation where I represent companies and sometimes large companies in those types of matters, having nothing to do with trust and estate work. But for me, the ability to have a lasting impact in a positive way on people who really, really need a trusted advisor who's going to do what they can to kind of lower the temperature of the situation to the extent that that's an option. Listen, there are moments. I'm a trial lawyer, and so my first job is to zealously advocate for the interests of my client, and that's always what I'm going to do. But there are lots of different ways to do that, and sometimes zealous advocacy for the interest of your client is making your client see that the traditional notion of zealous advocacy is not necessarily the way to go, that there is another path forward here, and that cooler heads do need to prevail. It's not always the case, but it frequently is, and it's frequently lost in the heat of the moment.
Yeah, unfortunately, our adversarial legal system is maybe not the best equipped for dealing with these sorts of fights where, where by nature, you're going to have a winner and a loser. And, normally the winner and loser is, who gets closer to what they wanted, right? But in this case, a lot of times, the winner and loser is less to do with the money, and it's more like a long-term view of like, well, we all win if this family gets along again. And sometimes getting your client the most stuff and really sticking it to the other party, even though they're winning, quote unquote, in the very short term in terms of the balance sheet, they've ultimately potentially created a problem that's never going to go away. Now they're a fight that will never end. So ultimately everyone will lose. Whereas if you're taking a different tact in the litigation, even now that there's already a fight to try to take the temperature down, as you said, then maybe your client ends up with a little bit less in the short term, but the fight is actually resolved. And so now in the long term, this doesn't come back up. And even if it's never kumbaya again, there's not further litigation and further hatred.
You're absolutely right. And you frequently see, even if there is an issue that's resolved involving one generation, if it's not resolved definitively, or if there are those lingering tensions, then it will continue and spill over into the next generation. And so you see these estates that get litigated kind of ad seriam, where each successive generation has new issues that have to be resolved because it wasn't done right the first time. But aside from the more nebulous emotional aspect of the dispute and this notion that, listen, if we can work together, then we can heal those wounds, prevent a further fracturing or splintering of this family over this issue. There is a very real world consequence to litigation, which is it's expensive.
Mm-hmm.
And so the longer it goes on, the more contentious it becomes. It can literally be a case of cutting off your nose to spite your face. Is that if your definition of winning is that the other side is losing, then yeah, that can be achieved. But frequently it's going to come at a significant cost to you as well, where whatever gains, monetary gains you might have achieved by getting one over on your sibling, or your father's second wife, or whoever it is that your adversary in the litigation, is Pyrrhic because it cost you so much money to get there.
Mm-hmm. And we talked about the human emotion of greed earlier, and I think this is also where fairly commonly you see the human emotion of spite come into play, where perhaps an initial fight is over, I don't know, a made-up number, $250,000, right? And one kid gets it and the other kid doesn't in the will contest, and and that's it. One gets all, one gets nothing. Well, the other kid maybe is not happy with that and is very aware of, okay, well, you got $250,000 that I didn't get. Well, now I'm going to bring further suits to make legal costs so that you end up having to spend that $250,000 very purposely on all these suits I'm going to bring against you now, just to sort of get my own pound of flesh out of this deal because I'm so unhappy with how the first thing turned out. And that is something that happens, I won't say often, but it's certainly not uncommon.
It is not uncommon, and that is also, listen, there are certain instances you can't predict, and there's nothing that can be done to anticipate what those issues are and to plan for them in advance. Frequently, however, parents know who their children are, and I have seen and I have litigated instances where it is anticipated that there is a beneficiary who's going to be causing a problem. everyone knows it in advance, and so you do what you can on the front end to try and plan for that eventuality. And you do that, one, again, we've discussed it a few times already, but it really is the truth: communication. Being open and honest and telling that person, you are not getting, Billy is not getting what Bobby is getting, and here's why. And document that to the extent that you can. I had a case once where there were two siblings. One was comfortable. It was a son and a daughter. The son had their own business, was able to provide for his family, did not need the money. The other one, the daughter, was not as fortunate, had a messy divorce, had a lot of financial problems, had some tax liens. There were a lot of issues there, and so the parents made a conscious decision and decided that they were going to give the bulk of their estate to their daughter, who needed it. This was not a very large estate, but it was going to make a material difference to the daughter and not to the son. The problem they had was they left a note. It was not part of the terms of the will or trust, but they left a note. They did not discuss it with him in advance, but they left a note explaining the rationale for their decision. And it ultimately resulted in, a lot of litigation because his feelings were hurt. He could not believe that his parents, it had nothing to do with the amounts involved. It was that she got everything and he got nothing. And he then viewed that in conversations that I had with him and his attorney subsequently. He was so racked with guilt over this notion that he was a bad son and that his parents were punishing him for not being there when he needed them, or whatever the issues were, that he was wrestling with those issues and doing it through litigation and trying to kind of lash out at his sister, who through no fault of her own, was the beneficiary of this decision that her parents had made, and did not participate in that decision. So, but back to the point about planning for these problems in advance. I've seen situations where, there's a no contest clause written into a will or a trust that says, I anticipate that my son or my daughter is going to contest this because of X, Y, or Z. And in the event they specifically call out the person, say in the event that they do, they get disinherited. Or, any fees incurred in defense of their contest, are charged against their distributive portion of the estate. And you put in specific disincentives in order to try and deter those challenges. And it works on occasion. Unfortunately, though, when you're dealing with very large estates, greed is a very powerful motivator. One of I'm a big fan of the television series The Simpsons, and one of my favorite lines that I use from that show when I'm talking to clients is, there's a scene where, Mr. Burns is the richest man in Springfield, and a little boy goes up to him and says, "Gee, Mr. Burns, you must be the richest man in the whole world." And he says, "Ah, yes, but I'd gladly give it all up for just a little more." That is ultimately what motivates a lot of the work that I do, is just pure old-fashioned, unadulterated greed. And so you can plan for it, you can anticipate it, you can, develop any bells and whistles that you can incorporate into an estate plan, and ultimately, it's all going to be for naught, because greed is greed. And the best example I have of that is one case I had where the decedent was a very wealthy woman, worth hundreds of millions of dollars, self-made. She had one son who was just a terrible human being by any objective measure of how people should behave, just failed in every single one of them. And probably because he was the product of poor parenting, had just been overindulged, and so never really developed into anything productive or useful. Just had this off-putting sense of entitlement that everything that his mother had worked her whole life to build was rightly his. And she disagreed. He was well provided for. He had received a lot of money throughout the course of her life, and real property and other things, and was generously provided for in her estate plan. But the bulk of what she had was going to charity. Charities that she supported, and a charity that she had created that was really kind of fulfilling her life's passion. And it was all extremely well documented. There were multiple iterations of a plan. She was constantly refining things. She was examined by, respected geriatric psychiatrists during each amendment to her plan. Everything was as buttoned down as it could be. And then after she passed, her son came forward with what he claimed was a deathbed amendment to her estate plan, giving him everything. And it was a handwritten piece of paper that was completely illegible. I mean, there were handwriting experts that looked at this thing. that all, even his handwriting expert that opined, I can't really make out most of this, but he insisted that the day she died in the hospital, literally lying on her deathbed, that she recanted all of the other sophisticated, complicated efforts she had made to, achieve tax efficiencies and provide for dozens of beneficiaries and all these charities to dispose of her estate worth hundreds of millions of dollars with this handwritten note. And that litigation took years and a lot of money to eventually resolve. So, greed is like I said, a very powerful factor, and people can get very, very creative in their pursuit of the almighty dollar.
Yeah, and obviously, logic sometimes doesn't have takes a back seat. Even when presented with all the evidence in the world, you can either not care about it and, try to get one over on people, or you can internalize it like your other client you were talking about did. And, even though you've been presented with their explicit reason, all your neuroses create your own other reason why this really happened. And that turns into its own thing. Unfortunately, we're running out of time. I'd like to thank Alex Weingarten just for being a fantastic guest. Thanks for coming on, Alex.
Thank you for having me. It was my pleasure.
And for all listeners, I'll see you, or I guess you'll hear me, on the next episode of Celebrity Estates, Wills of the Rich and Famous.
Thank you for listening to the Celebrity Estates Wills of the Rich and Famous podcast. Click the subscribe button below to become notified when new episodes become available. The information covered and posted represents the views and opinions of the guest and does not necessarily represent the views or opinions of InformaWealthManagement.com. The content has been made available for informational and educational purposes only. The content is not intended to be a substitute for professional investing advice. Always seek the advice of your financial advisor or other qualified financial service provider with any questions you may have regarding your investment planning.